contract law. And the reason we are doing this is some of you may very well have had an introduction to English law, contract law, at master's level or at BA level. But we know from past experience that many of you don't. So it was felt that this was an opportunity to cover this huge area in a nutshell. And again, the focal point, as it will be with the next lecture, is really about what's relevant to us as architects. And interesting enough, Alice and I were talking at the break about this when we were talking about the case study. And really, that last section about procurement, construction, and what we were saying was what we were really looking for is your understanding of what the architect's role was in that particular context to do with procurement and contract. And this is very much the same thing. And the next lecture will also be the same theme. But in order to get there, we do have to go through some principles very quickly. So I'm going to give you a very quick overview of the current play in the sources of English law. And I say current play because depending on what happens next week or doesn't happen, you know, some of the things will change that I will talk about, but you'll see what that is. We also need to make a quick distinction between private law and public law, a distinction between civil and criminal, and then very briefly look at the place of European law. So that's the sort of snapshot of the English legal system. And then I want to say or ask a question, how does this relate to contract law? So as you could expect, the contracts we form are really a subset of the English legal system. They sit within that system. So we'll need to have a little bit of an overview in order to understand where it sits. And then there are some routine principles, or not routine, but some basic principles that you need to understand. And then, having understood that, you will be able to absorb what Indu Ramaswamy is going to be talking about tomorrow in terms of the detail of the architect's appointment, forms of appointment, all those sorts of things. Be able to absorb those in some more detail. But you need the principles first. Otherwise, what will happen is you will just sort of learn by rote, effectively, by heart, the sorts of things that Indu will say, but without really fully understanding them. So we'll talk a little bit about how you form contracts, and then how you end them or discharge them, and then a little bit, a tiny bit, about what happens when there's a problem. But there will be a lecture in July, I suspect, around what we call dispute resolution. So that, in a nutshell, is what we're going to be covering in the next hour and a half. And we start with this idea of what are the sources of English law, where does it come from? And I will explain as we go on why this is important for our construction contracts and our other contracts that we form with our clients. Okay, so at the moment we have effectively three sources of law. And I also want to place this in an international context as well, so we'll do that in a second. But we'll start with these three principles. The one in the middle is what we call the common law system. Again, I'm not expecting you to readily understand this, but I need to show you that there are a number of elements of our legal system going on at any one time. And Anglo-Saxon jurisdictions, that's ourselves, particularly the States, Commonwealth countries, so we could say Hong Kong, going through to Australia, Canada, Sri Lanka, South Africa. Generally English-speaking countries with what we call Anglo-Saxon jurisdictions have what's called a common law system. And the common law system is based around what we call precedent or case law. I'll expand on that in a moment. But I want you to think of precedent, curiously enough, in the way that we use precedent in the way we think architecturally, the way we use precedent. I mean, it's used in a slightly different way, but the same principle applies, that we are building our decisions around a body of knowledge that already exists, but it is being added to on a continuous basis. And in the same way, in the way that we use precedent in architecture, we use it when it is relevant to the design challenge that we're facing. We don't use precedent that is irrelevant or has no basis, the facts are different or the situation is different. So, instinctively we know through our studies, history and theory, all those sorts of things, but it could be around precedent in environmental control, it could be about cost precedent as well. We're using examples that are relevant to inform our own decisions, and the law works like that too. And it does it in a fairly organic way, and that is unique to the Anglo-Saxon common law system. Common means it's common to everybody. That sounds a desperately obvious thing to say, but the concept predates, effectively, lines of communication around the country. And when I say lines of communication, I mean as sort of basic as roads. So the idea of communicating with other parts of the country was very, very crude. And the principle that was set up was that decisions that we would make in one part of England would be identical, given legal decisions, judge-made decisions, would be identical given the same facts, the same circumstances in another part. That was quite a powerful idea, but quite a challenge when most people didn't move more than about sort of 6 or 8 kilometres away from where they lived, where we worked on different time zones. We only unified time really towards the end of the 19th century. But this principle was that everybody, and also would apply whoever you were, whatever status in society as well. So given the same facts, same circumstances, the law would make the same decision. And the only way it would know that would be by having some sort of basis of precedent, what's called judge-made law. And one of the advantages was, of course, it was consistent. So the holy grail for a legal system is that it is consistent, that they're making the same decisions. One of the other advantages is that it's organic. As circumstances change, you can change your decisions. So you'll find maybe that the precedent doesn't apply in the same way that we would look at, if we were looking at some architectural precedent, we would very rapidly realize that it wasn't relevant because life's moved on. So it has this organic flexibility with it and flexibility within it. And it is independent of any interference from Parliament, of state. These are decisions that are made purely on the facts within this fairly robust legal system. Okay? And it's useful because of those things I've said, that it's flexible. We don't need to know the system or the structure within which those operate particularly. But clearly there has to be a robust system as well that allows those things to happen. And there has to be professional people who understand and know the precedent, so you can see a whole separate body of knowledge growing up. And that also works well when the state is relatively weak in terms of its effectiveness. So that was also quite persuasive when it was dreamt up. But the state does make laws. In fact, what we think when we think of a legal system, when we think of law, the law, we tend to think of acts of Parliament, statutes, regulations. The building regulations sit below the Building Act. That's a piece of legislation that's been through Parliament. So we have this other layer, or this other set coming in around statutes or acts of Parliament. And a way I often look at statute is that it sort of steps in to correct errors in the common law system. So it will, if the common law is seen to be, although it's organic and flexible, isn't moving fast enough to different sets of circumstances, then the state can step in and say, do you know what, we'll create this piece of legislation that overrides this aspect of common law. In that sense, it's reactive, but it also can be quite political. So the state can use its acts of parliament as an instrument. Now, in a democratic environment, we would do that often as a sort of political decision. So the Human Rights Act was a piece of legislation that came about. It was a political decision to introduce what was effectively pan-European legislation and embed it within the UK system, and that was a political decision made by the incoming Labour government in 1997, seems a long time ago, which ended up in the Human Rights Act. And the rest is history. Other governments have tried to repeal it because it's complex, and they've hit a wall and realised that it's so politically incorrect to do it that they take it no further. But that's an example. We could see also that post-Grenfell, which I mentioned a little bit earlier, legislation will come out of Parliament that will somehow react to the deficiencies of the current system. And so Parliament will act in some way. It tends to be reactionary. It's very unlikely that it's proactive. All well and good. So we have these two things going on together, and the courts use both. They have to have a common law, and they have to be knowledgeable and aware of how statutes impact. And then lastly, we have a thing called European Union law. And as you probably know, one of the main arguments about leaving the EU is that we get back our control over our own legal system. It's a little bit of a false argument, because actually EU legislation has to be enacted within the UK, within England and Wales. It's not as though it's automatic. The EU issues what are called directives. They have no particular legal standing until we enact them. If we fail to do that, then they can take sanctions, but it's up to each country within the EU to do it in their own way. So if you look at an EU directive, it doesn't read like a law, it's a series of directions. So the classic one for us will be the CDM regulations grew out of a European directive, which I think is called Mobile Construction Sites. It's got quite a quaint name to it. And we enacted it, we brought it in fact we brought it in below a piece of existing legislation called the Health and Safety at Work Act, 1971 I think it was, even though we brought it in the late 90s or whenever it was. If we'd failed to do that, then we would have been subject to some sort of sanction. So those three things work together. So that's the summary really. And I haven't distinguished between civil and criminal yet, or private and public. We're going to be talking mostly about contract law, and contract law sits within actually the private area of the law. It also sits within what we call civil law. So, and we would hope that in your day-to-day dealings as an architect, you don't get too heavily involved in the criminal law. But I'll give you some examples in a moment. And there's an interesting characteristic of contract law is that the state, Parliament, the EU, is very reluctant to step in and control the agreements, the obligations that we make to each other. There are very few pieces of legislation, in fact. We'll touch on them, or touch on some examples. Whereas they will, there is an exception to that, actually. If you think of your contract of employment, employment law is an area that has grown, I'm not sure whether it's grown exponentially, but it's certainly grown hugely since its origins in the 1970s or late 60s. essentially our employment contracts are just that. They are a transaction, they're a contract, they're an agreement. But it was felt that the common law wasn't working. So the judge-made law, precedent, the organic nature of it wasn't working. Society had moved on as well, mostly around an imbalance of bargaining power. We have very little bargaining power at the point at which we agree our employment contract. Social attitudes to that changed. Prior to that, of course, the courts and society generally say, well, that's the fact of life. That's how it's always been. Employers have the whip hand. And what are we going to do? Well, the state introduced legislation, so they stepped in and said, there's this imbalance of bargaining power, there's imbalance of information, there's imbalance of understanding and knowledge, which makes the employee potentially vulnerable. So, this common law transaction that goes on is actually open to abuse. And so we'll see various examples of that. So employment law is a huge area of the legal system, but that is an exception, I suppose. So we're generally going to be in the private law area. So if I can just distinguish between civil and criminal, and I say we really want to spend our lives sitting on the left-hand side here. I'm describing it as the law which concerns relationships between individuals and groups. The example that we're going to look at really a little bit later in this session is contract law, and that sits within what's called the law of obligations. It is what it says, the obligations that we make to each other. In the case of contract law, this is a quite clearly defined set of obligations, and we'll expand on what we mean by that. But we also recognize that we have obligations to other citizens that have got nothing to do with the contracts that we might draw up between ourselves, that we voluntarily agree or enter into. That we have these wider obligations and rights. And that comes within another subset of the law of obligations called the law of tort. We're not going to go into the law of tort particularly, but examples, we will cover one of them in the next session, trespass, negligence as a classic, law, classic tort. Tort comes from an old French word meaning twisted, sort of torsion, get it from the same word, or it's a wrong. So, and that impacts particularly in property and land law, so guess what, we'll touch on that. And because it's about obligations that we make to each other, whether it's contractual or whether it's around rights or wrongs to citizens, it is based around what's called a system of compensation. So, and there are various principles about that. So the principle around contract law, for example, is that if you fail in your obligations that you've agreed, the system of compensation takes you to the point you would have been if everybody had met their obligations. Interesting enough, when it comes to considering the law of negligence, it works the other way. It says, we will take you back to the place you would have been if this negligent act hadn't occurred. So when when people go for criminal injury claims, it's always around, literally it is about compensation. The compensation is about how do we value the loss that you have experienced that otherwise you wouldn't have done. How can we value what it is to take you back to where you would have been should this loss not have occurred? But construction contracts particularly work the other way. They'll say, where do we take you in contract to where, if everybody had performed what they said they'd performed, where would we be? So actually they operate in different ways. The criminal law is different. It's about relationships between individuals, community and the state. So examples might be, let's say, things that we don't particularly want to get into, but it could be fraud or theft. I've come across those with my work at the ARB. Could be equal opportunities. More likely areas you'd come up against it is health and safety legislation. So I've just touched on the CDM regs, Health and Safety at Work Act. you often hear about people being prosecuted under the health and safety legislation. This is not about taking people to different places. This is purely around a system of punishment, a series of fines, could be imprisonment. It's not about redressing a balance. You might wish to take a separate piece of legal action to try and do that, but primarily the state is concerned with the system of punishment, in other words, to stop people doing things again in the future, or certainly to show that the state takes this so seriously that people have to be punished for, in such a way. It also applies to planning legislation and listed buildings, so architects do get prosecuted for planning infringements, certainly for listed building, infringing the listed building legislation. And the example I gave you a little bit earlier in the last session are about the ARB and its code of conduct. Actually, when they receive a complaint, they will often prosecute, well not often, but they may prosecute the architect under the Architects Act 1997. And that is a criminal act. Yes. So it isn't treated actually as a criminal act, but particularly, but it is literally, it's around a system of punishment. You get fined, you might in worst case be struck off the register. Okay, so there's a very different things. We don't really want to be in either of these places, but we're more likely to be in an area where we have a system of compensation. So, given that sort of fly-through of what the English legal system is about, we'll now try and dwell particularly on where contracts sit. Okay, and we could ask the question, what is a contract? And because this is about the relationships we establish, the obligations we establish with each other, it's quite fluid. There is no single fixed definition. And I could say that as well at this point that the systems that operate in other parts of the country, other parts of the world, and interestingly, particularly in other states in Europe, are different from our common law system. They tend to operate what's called a code system, which is around a fixed set of codes. So, the court system applies these codes. The codes are agreed at top level. So there are contractual codes, there are health and safety codes that operate in France, Germany, Italy. So quite a, that is in a sense at the heart of some of our tensions with other European states, is that we have this very different system. Anyway, less of that. But it also means that we can't go to the statutory code, particularly, certainly as contracts very much a private law. It's difficult to go to an authority from Parliament that says this is what a contract looks, smells and feels like, which sounds a bit strange, but it's true. So we have to do other things. We have to ask questions. And you'll find one of the characteristics of the English legal system is it does try and ask questions, sort of odd questions, and find answers in rather strange ways. And it does it, of course, through this system of precedent as well, where people have really thought through the problems, they write up their decisions, and those decisions are published on what are called law reports, so they form the basis of precedent. But we know there are certain things that we have to have, and first of it is that it's an agreement. And or it could be considered to be a promise. But whatever we say, it's actually a promise or an agreement that the law will enforce. So we're looking for something to sort of turn the words around. We're looking for an enforceable agreement around the obligations that we will make to each other. And that enforceability is important because we have to, if we want to make something enforceable, then it needs to we need to know why, where and when. Because you and I clearly make obligations to each other, day in, day out, but we're pretty clear that they are of a particular status. We certainly wouldn't consider going to court or taking legal action because you might have failed in one of those more social obligations. You agree to meet or you agree to borrow something, or and you fail to do that. We're always quite missing the target a little bit. So that's pretty clear. And we could be quite clear about where we definitely want things to be. You know, these obligations are so important that if there is a failure, then we want them to be enforceable. And then there's the grey area of where these decisions are taken. Yeah, I think it's particularly relevant to us as architects because the relationships we build with our clients, the obligations that are set up between us, are very often start in a fairly organic, I'm going to say informal, but depending on the setting, let's just say informal way. And there comes a point where we need to establish some sort of formality. And the formality might be, we need to write down what it is that we are agreeing to do. We need to write down our obligations to each other. And at some point we need to say, these are so important that we want to make them enforceable. And the way you, but of course you don't say that, but you will say, we're going to form a legally binding contract. And so we will now sort of unravel that and find out how we do that. And of course, the key reason why we think it's important is that the system of compensation kicks in, and that we can have a dispute resolved in some sort of neutral forum. That isn't necessarily the courts, but it could be. Increasingly, it isn't. 90% of disputes, contractual disputes, are dealt with privately or outside the court system. Okay, so we want compensation for that non-performance. Examples of contracts, in a way you are all very experienced in contracts of one shape or form. You've got your employment contract, you may have a rental agreement, you may have a mortgage or credit card agreements. In a professional context, we make our agreements between client and architect using the RIBA forms or using NEC or the ACA. And we also, again, sort of jumping ahead, we use construction contracts. That's the way we get things built. We talk about the contractor, that's because they have a contract. And then we've got examples of that would be SBC, NEC4, FIDIC, if some of you are using that. Okay, so as you can imagine, the law affecting the contracts is exactly the same as the common law system, some statutes, and European law in contract law kicks in very, very limited circumstances. Interesting enough, if any of you have been following the fiasco around the ferries, the ferry contracts the government's agreed for the sort of post-Brexit, traffic jam that's going to occur at Dover, you'll know that not only there's been a fiasco of one of the ferry contracts, part of that was because they had used a device to sidestep European law, and they thought they were clean on that, and then Eurotunnel stepped in and said, well, actually you haven't followed the basic requirements of transparency and fairness in seeking tenders for public contracts, and we want compensation, or we're going to take you to court. And the government backed down quite quickly, and I think gave them a bung of 13 million to keep them quiet. And that's the origins of that are actually in European legislation, but it's around the invitation to tender for work, and we'll touch on that in a moment. Okay. There's also international contracts. Many of you will be based doing international construction contracts. And I just want to explain to you that really the same things apply. There are obviously some jurisdictions that use a common law system, others use a code system or statutes. And then we do get examples where to resolve problems, to resolve disputes, and this, funnily enough, is actually at the heart of some of the problems with the dreaded backstop agreement, is how do you resolve an international dispute about that? Which forum do you take it to? There's been suggestions that we go to the UN because the UN is a sort of neutral body. Nobody seems to like that idea. but there's a lot of precedent in the sense that the UN has a clear system that's been set up to resolve international trade disputes, and there are a number of protocols. Anyway, I hope you won't have to get involved with, but it's there. But I'm just trying to say that the same systems apply, the same forces apply. Okay. So if I just to summarise the laws that might affect English contracts, and this is not exhaustive, but these are going to give you examples. What I've done, and what you'll find with this lecture, and it isn't really in any of the textbooks, but I found this was a good way of explaining it to myself, is to think of contracts as a process. And I have a process where we have pre-contract, what happens before we enter into a contract, what happens when we make an agreement. We'll probably use the word interchangeably. What happens when we get failures in the contractual performance, when things don't go as they should? How do you achieve compensation? And then, are there any liabilities after the contractual duties have been discharged? So after the contract's finished, does anything else remain? And the English legal system said yes. And the question then is, how long should those duties remain? And that was the case where actually the common law system failed, and Parliament introduced a series of statutes that actually made things easier. They didn't make things more difficult or worse. They just introduced clarity about when our liabilities end. And I've touched on that piece of European legislation. I probably should put that right at the top, because it isn't a statute, but for public procurement, there's a set of regulations, and that's where the government fell foul with its Ramsgate ferry and general ferry contracts, because it didn't follow the public procurement regulations. So you'll see, therefore, that the good news is that there aren't, think of how long we have been making contracts between ourselves, how often we do it, even in a sort of industrialized society or post-industrial society. You would expect, given the millions of contracts that are formed, that there would be far more intervention by the state. But you'll see it's very, very limited. It grows, and it grows in a way, say, that the Supply and Goods and Services Act has had a supplementary piece of legislation in 2015 that we could add to that. So this is not meant to be exhaustive, it's just giving you a few examples, really to demonstrate the point that there is very little legislation. The state doesn't want to interfere with these obligations that we set up between ourselves, other than in the case of consumers. I mentioned the place of the growth of consumer awareness, consumer power in the context of the professions. It also relates to contracts. In fact, its origins, I suppose, are very much in contracts. It's a bit of reactive legislation, which is saying the common law system is out of step with society's feelings about the imbalance between the consumer and whoever's selling them those goods or services. And for us in construction contracts, we have a thing called the Construction Act, which introduced, and it's unique, a statutory process for dispute resolution in construction contracts. And our professional services agreements are considered to be construction contracts. It's not just building. What is a construction contract and what isn't was entirely a political decision. And those who all know that the Construction Act has been changed. It grows, so based on how the first run worked, they made changes to it, more recent legislation. And that's now embedded within our JCT contracts, it's embedded within our professional services agreements. It's very unusual, it's broadly unique because it applies to a sector, the construction sector. It's been by all intents and purposes, so successful that it's now being looked at by other industries to think if they can use this same hybrid dispute resolution process in other disputes in other industries. Then on the common law side, well, we've got contract law, this idea of precedent, legal cases. And where does that kick in? Well, at pre-contract stage, it could be around tendering, it could be around letters of intent. You won't find any legislation that covers tendering or letters of intent, other than in the public sector, the public procurement regulations. Then, as you can imagine, most legal disputes are around performance, who does what, but very often the first question that's asked is, what did we agree to do in the first place? And you'll see as we move through this process, there is an obsession within the English legal system of saying, what was it did we agree to, and when did we agree to it? That is a characteristic of the Anglo-Saxon system, same with the American system. It's different in Europe, it's different in the Middle East. There's a different emphasis around when these obligations were created. And then, very straightforward, if we now know what it is we've agreed to, what has happened with this failure in performance, or have we performed everything we said we'd do? And if so, how do we go around ending the contract? When I was sort of sat through lectures on contract law, we did an awful lot about how do you define a contract and how do you start it, but we never quite tackled that question of how do you get out of it, how do you end it? There, we'll talk a little bit about that. And then I say post-contract, there are aspects, as well as the Limitation Act, there are things like latent damages and your liability. Okay, so this slide really just summarizes, gives you a flavor of the balance of legislation and common law. It's not comprehensive, by the way. That's the whole intention. It's just giving you some examples. Okay, I said I'd seen this as a as a process, and so we're going to spend the rest of this session going through these 4 stages, really. So just to recap, we've had a fly-through of the English legal system. We now know that we're sitting within an area that's called private law. It's in the civil system. We don't need to know too much about that, other than, if we had a disagreement, it would be dealt with differently from a criminal case, which would be around punishment. So we're looking at systems of compensation primarily here. We know there's a common law process. We know there's a statutory process. The statutes don't interfere much. So what we're going to do is now look at the principles and the problems that occur at each of these stages. And I've done it as these 4 stages: a pre-contract, the agreement, so pre-contract as in negotiation, agreement, do we have a contract, and if we do, what's in it? I say the obsession in the English legal system is trying to get to that point there. So when you get a dispute, the first question you ask is, was there a contract to start with, and if there was, what was in it? Now that may sound like 2 terribly obvious questions, but you will know from your own experience, for example, in dealing maybe with subcontractor packages, the free, the movement of different bits of information, different quotations, different payment terms. It's often difficult to know, especially if there's been a process of negotiation, to find out exactly what it was that you agreed to. That may sound a bit strange, but it's often the case. But if we can get to that point where we know where we are, we then can say, okay, we've got a contract. How is that contract to be performed? And if we know that, then we know where there might be failures in the performance. And if we got failures in the performance, then this idea of a system of compensation might kick in for what we call a breach of contract. And then that last question is, how do we end the whole thing? Well, you can do it just by performing what you said you were going to do. And then that's it. You could end it by agreement. There could be a fundamental or serious breach, or there might be what's called frustration, something that frustrates the contract. So Deeply tragic example of that might be the flooding in Mozambique at the moment. That you could not continue with a set of obligations that you'd established before that event. The contract would be frustrated, it wouldn't be complete, but clearly you wouldn't necessarily be going for compensation as a breach of contract. You'd have to say, neither of us can continue because of this set of events. And that's a sort of example of how the law says there are, we can identify different sort of incidents that we can cope with exceptions. We'll come back to that very briefly at the end. Okay, so what makes that contract? How do we know that we're getting to a contract? And we'll talk about this pre-contract and process of negotiation. Well, I said there weren't any sort of clear definitions particularly, but we know that we have to have three elements. And if you only have one of them, or you only have two of them, then you don't have an enforceable contract. So given the I was saying about how we make agreements between each other socially all the time, of course we do that. The technical terms are therefore somebody makes an offer and somebody accepts that offer. And we could do that between ourselves. We know that we do that quite naturally. But we also know that it's not a contract. And we know that because we never intended it to be legally enforceable or to be binding. We hadn't sought to make that promise. It's not that important that I would ever make this enforceable. And similarly, it would require what's called consideration, which I'm sorry is a technical term. I'm trying to avoid technical terms if I can, but that's just the legal term. And I talk about consideration being performance. It's about, A is, I'm going to give you a product, provide you with a product. That is my, my consideration, my performance, and in return, you're going to pay me. So that's your consideration, that's your effort, that's your performance. And I have on occasions had to say politely, to clients, when they haven't paid their bill, I say, look, we've done what we said we'd do. We've carried out all this work. We've performed our duties. We're only really looking for you to make payment, which is, your performance in the bargain. That's what you have to do. You say it the wrong way, it gets misinterpreted, but that's the simple transaction. So there has to be this transaction taking place. Okay, so then we get to the question of, so we're now going to drill down a little bit further and say what is an offer, what is acceptance, and then we'll expand on these other things. So an offer could be oral, or it could be written, or it could be what we call by conduct, by some sort of action that you've carried out. Example, I suppose today, I can't believe, I'm not sure whether, I suppose we have had an offer and acceptance. Alison probably said, would I come and do a lecture? That was the offer. I probably said, yes, I would. But even if we hadn't done that and I just turned up and I do what I do, there's a sense that I have fulfilled what it was that was required. So already you can see this is quite fuzzy, quite organic. And what is also noticeable is there is no sort of set pattern to this. Given that we are trying to set up a series of obligations, this is quite vague, especially when we think that one of the purposes of a legal system is certainty, that we are trying to create certainty. We are also trying to create consistency in decisions that the law takes. And the starting point for that probably is consistency in the actions that we take when we are doing this transaction, when we're creating a contract. Which is a rather long-winded way of saying probably if we're trying to create certainty, then the idea of an oral agreement is risky. The way we manage uncertainty is through risk management, and oral agreements sound pretty uncertain, especially if it comes down to architectural services, which are complex. And also, that's our business model. So the example I gave you in the first session was, I could have said, English law allows us to make oral agreements. I didn't quite put it that way. I'd said, The office runs okay. We just do it by gentleman's agreement, word of mouth. We send a bill, we get it paid. Conduct, I suppose you'd call that. But actually, the profession says that's not enough. We have a higher level of behaviour that we expect. We say you must have a written agreement. So that's the sort of professional higher barrier. It's beyond what's required by the English law, but it also makes sense because what we do is pretty complex. Okay. That then gets you into thinking, well, what is an offer? How do you accept it? And that may sound like a rather academic question, and we also then get these rather quaint phrases like invitation to treat. Because you sometimes want to distinguish between what was an offer and what wasn't. So an invitation to treat is an invitation for somebody else to make an offer. So we've got a sort of stage before this now. We'd like an offer, but we want to invite you to make one. Okay? And grounding that within construction, we would of course say a tender. What is it? We go out to tender. What's the basis of that? Because we put a lot of time and effort into tenders. Well, actually, when we go out to tender, we are not saying that the act of tendering is the beginning of a set of legal obligations. It's not creating any obligation. All it's doing is notifying potential contractors to make an offer. So it's what's called an invitation to treat. It sounds a rather quaint phrase. It probably comes from the 19th century. And the tender that the contractor returns is, of course, an offer. We offer to carry out this work for such and such. And you needn't worry about the law cases it creates at the bottom, but other than there aren't many private law cases where there's been confusion about tendering. This particular one was about when was the offer made. In fact, it was made by postal offer, and it was whether it was received. So that legal case sought to create a precedent to answer a problem about if somebody had made an offer and it hadn't been received, what's its legal status? We don't need to worry about that. The reason I put it up there is to show you that really there aren't many precedents that the law would rely on, and they will have to scrabble around to find them. But it was a very bizarre case, that the fact. Anyway, you needn't worry about that. So a tender actually is an offer. So when we send out our tender documentation, it's an invitation to treat. In doing that, there's a sort of process of negotiation that will take place. So the tender, the offer, the post-tender negotiation. So now we're into this really murky territory, of those of you who've been through this, of we're in quite a fluid environment where, although we might have some clear paperwork in place, it's not always clear what the offer might be, and certainly how we might accept it, because things change. So I'm not giving you a resolution for that, but I'm just saying, there is an opportunity for misunderstanding here. So the clarity in the tendering process, the clarity in documentation is absolutely essential. I have had situations, you may have experienced it as well, where we've had a negotiated tender, and of course the bottom line is agreed, or the contractual figure is agreed by the employer and the contractor, but the actual detail of how those figures are made up was not resolved. They just agreed, they did a deal. And of course, there then has to be a process of adjustment that takes place. That in turn is a process of negotiation. And it becomes particularly problematic if there's a variation in some of the work where you hadn't got a real agreement at the outset as to what that original cost was going to be. And guess what? The contractor is always going to say, well, we didn't reduce that bit, we reduced something else. So even in that well-documented situation, you can get a lack of clarity. Okay. So there may be some rules that have to be established around conduct. And the general rule is that an offer can be withdrawn at any time up to its acceptance. So a tender can be withdrawn. So we're not going through tendering processes today. I think we'll probably do that in July. if I'm doing that lecture. But given the complexity of construction, given the way tendering works, one of the documents that you might need to refer to is any sort of good practice, best practice, codes that would relate to tendering. Now, it isn't my job today to muddy the waters by talking about that. But we've all had contractors withdraw their tender. And of course, so although I said an offer could be made orally, it could be in writing, could be by conduct, guess what? The acceptance could be the same. Okay? And you can see that the further we get away from a written contract, so things like just by conduct or an oral agreement, we're getting a lack of clarity, a lack of certainty as what it is we've made obligations to do. And that rather bizarre case was around a company that supplied coal to the Metropolitan Railway. They didn't have a contract. The railway didn't renew the contract, but they kept on supplying coal, and they asked for payment, and they said, sorry, we haven't got a contract. And the sort of helpful insight that the judge offered there was, just because you thought you had one isn't enough. You have to prove it by actually having done something and some sort of transaction taking place. So although that's a rather obscure, again, it's a rather obscure case, part of this is to show that these things don't happen very often. It's also just an indication of how precedent can inform, legal decisions. And you don't need to worry about that. You'll never be tested on law cases. So what are the problems? Well, I've sort of touched on some of those. This idea of a lack of clarity. The first one is a blindingly obvious one. Very often, because this is what's called a bargain, there's an equality of information and inequality of power. Even in the professional world of construction contracts, those two things are present. Certainly the inequality of power. So that negotiation process when it's thought that the client is in a particularly strong position can lead to an inequality that doesn't actually benefit the performance of the contract. They might think it does, but it doesn't. And that's all taking place before the contract's formed. Then we get to this idea of an intention, promising to do something or provide something. So in a sense, for the other side of the bargain is somebody saying, I'm going to do this, I'm going to, there's an over-promising, what might be called misrepresentation. So we're making false promises around the sort of second-hand car, Now I know we're not talking about second-hand cars in construction contracts, but you, in your dealings in a professional environment, might be considered to perhaps overpromise in the scope of services you're going to provide. Classic one, clients might misunderstand the role we play in the planning process, because we might use the word that we're going to obtain planning consent. We're promising something that we can't deliver. It's outside our control. Planning consent, it's a public democratic process. We can do our best, but the decisions are made by local authority. But the reality of this is again, this sort of imbalance of information, and this was an early piece of legislation because it tried to address a problem, relatively early in the 1960s, it tried to address a problem whereby should you be liable for something you said before the contract was formed? Because because the contract isn't there, we don't have a system of compensation. We haven't got an agreement. But what about all the things that were promised before then? And the common law system would say, well, because there wasn't a contract, they don't apply. You can promise what you like, but you can agree it, you can believe it, but that's your problem. And this is where the state stepped in and said that's probably not right. The common law system isn't working. Maybe if people are being induced to make decisions through what's called misrepresentation, then there needs to be some system that allows for compensation to take place. Anyway, it's just an example. There also, you have to have the intention to create legal relations. So you can't try and form an agreement about something that is outside the law. That may sound blindingly obvious, but there have been cases where people have tried to impose illegal agreements. But more importantly, when it comes to commercial agreements, this is about the intention to create legal relationships. And with a commercial agreement, there is a presumption that when you have made an offer and it's been accepted, that it's going to be legally binding. And it's then up to the person who wants to escape those obligations to prove that it should be overturned. So that, again, precedent's quite useful here. Rarely they're saying the consumer is different, but actually in commercial contracts, and we're involved in commercial contracts most of the time, there is an assumption that's going to be legally binding, unless you say it's subject to contract. And so those phrases, you've probably heard this, subject to contract, it actually has huge legal power because it allows you to say, this is an agreement, but it's not the contract. Now, why would you do that? Because you might be still negotiating. There might be other things that are going on. That, again, may sound slightly academic, but we do this all the time with letters of intent. Probably come across letters of intent. We often use letters of intent actually for our professional services. That's a bit dangerous. We use letters of intent for construction contracts. And the question that arises is, are these letters of intent binding? Have we got a contract? And the default position is probably yes, unless you say subject to contract. So, and we've all done it. But it depends on the details, so I can't generalize about it. But they're commonly used to try and set up contractual relationships before the contract terms have been fully agreed, particularly in construction contracts. The problem occurs is that a letter of intent could be a contract. So when you get a dispute, and it happens, the first thing you say is, well, what did we agree? Let's look at the paper trail. And depending on which side of the fence you're on, which side of the argument you're on, you'll say, we are relying on the SBC 16 contract, because that's what we said we were going to use. The fact that we just sent a letter of intent saying that we're going to use that, I'm relying on that to say that's what we're going to use as a contract. And if it suited the other party, who would be disputing this, they could probably say, well, no, actually, we never formed that, we never signed that. All you ever did was send me a letter. And the letter didn't have any of the terms, didn't have any of the payment terms, any of the dispute resolution terms. It didn't have anything to do with delay, loss and expense. All you did was send me a letter saying that's what you plan to do. And I don't want to generalize because it does depend on the facts, but there's a relatively recent and interesting case to do with Ampleforth College. It wasn't a firm of architects, a firm of project managers, who let the contract as a series of letters of intent. So not only did they do one, they did another, and then they did another. Got to the end of the contract, they got a dispute about payment, about delay, at which point the client would say, well, actually, we are relying on the terms of the contract. JCT, SBC 16, it was probably SBC 11. And the contractor said, no, you never sent us a contract. All you did was send us these letters. And the letters are very vague. They just said, please spend such and such, we allow you to spend such and such a money up to a particular point. And I say each of these cases turns on the facts, but it came down essentially to, the claim was about delay, because the contract will say there is a system of compensation in place at a predetermined rate, we call them liquidated damages, that are set out in the contract if the works extend beyond the completion date and there is no agreement to that extension. Therefore, we're going to claim all this money. And the contractor said, sorry, I'm relying on the letter that you wrote to me. There was nothing about liquidated damages. There's nothing about compensation. Where did you refer to that? And the judge agreed with them. So then the next question was, how did the client then go and obtain compensation? The compensation they felt they were due. Was this a failing, in this case by the project manager, to carry out their duties as contract administrators? And so that created another case. And yes, the answer was yes, they had failed in their duties. And so the project manager, quantity surveyor, had to compensate the employer for their failure to agree the contract. So can you see how these things work? Okay. Then we've got this idea. Yes. Memorandums of understanding. I'm interested by that because I've never really used memorandums of understanding in the context of construction contracts. I use them a lot at university. We have MOUs with all sorts of people, and we're very clear that they are not contracts. They have no contractual weight for a number of reasons. One, because we say so. And the second one is actually this slide. There is no evidence of what we call consideration. No performance has taken place in terms of money changing hands. There's been no contractual agreement. All it is an understanding. It's nothing more than that. I have to say the very first one I did was with Chinese University of Hong Kong, and I had to drive it home to my boss at the time. I then took on his job, actually. I had to try and drive it home to him that this was not a legal agreement. He needn't worry about the detail. It had no legal force at all. He wouldn't accept my view. He wanted our lawyers to look at it, so I think we went and paid a shed load of money for somebody just to agree with what I'd said to him. But we are quite clear about that. So my starting point would be a memorandum of understanding has no legal force at all contractually. Don't think we often use them. We would tend to use letters of intent. But one of the key reasons is no money was changing hands. The question I would ask is, if we failed in our performance on this memorandum of understanding, what compensation is due? Well, there's been no agreement about any sums of money at all. There's no consideration that's taken place. There's been no performance issue. This is purely an understanding that we might do something in the future. It's a sort of sign of goodwill. I had a situation last November where I had to go to a city in northeast China to sign one of these things because the Chinese wouldn't do anything until they'd had a formal signing ceremony. Even though I'd actually signed it in May and sent it to them, they insisted that it be signed and witnessed in a sort of formal a formal event. Anyway, we had to do it, but maybe that's a sort of cultural issue around what these memoranda mean. Anyway, I digress. Let's get back to the main plot. Consideration. So that's an actual promise, and in a sense, it's what we've got here, which is really in the architect's appointment. We would promise to carry out a series of services. The client promises to pay us something, and we would want to see evidence of that transaction, of the consideration taking place. One other thing is we have to demonstrate capacity. Now, I've just included this for completeness, but if you're a minor, or if you're mad, if you're criminally insane, then the law will say, actually, you weren't capable, you didn't have the capacity to enter into that contract and to make that happen. Okay. So we've got a contract. What have we agreed to? Well, I'm going to try and speed up because we do want to try and finish sort of vaguely on time. But I mentioned the dangers of oral agreements. Here's a great one. Those of you who are petrol heads or Formula One fans will recognize this guy because he pads up and down the pit lane, giving his opinions about the world and everything. And the reason he does that is because of the law case he lost. He was a Formula One team owner at one point, and Formula One relies almost entirely on sponsorship, and and he thought, or he alleged, that he'd got an agreement from Vodafone, ironically in the back of his car on his mobile phone, to a $150 million sponsorship deal, and he was relying on the phrase, "You've got the deal." He said, "Vodafone told me that we had a deal." And what made it worse was, of course, Vodafone then went off and signed a deal with Ferrari, so that didn't help him very much. This was a lot of money, so it was worth him taking a punt and going to court about it. He lost the case, and I don't want to read it out. It's quite an old case, but it's still quite amusing and relevant. But I really love the phrase, "Judge," this is why we're not judges and judges are, where he said, "The inherent improbability of an agreement of such a nature for payments of such a size being made in such a manner is obvious. At the conclusion of the evidence, the inherent improbability was more than fully matched by the reality," which is a very polite way of saying he lied. And in taking the evidence, they said, he was an wholly unsatisfactory witness whose evidence became more and more contrived and unsustainable. In contrast, he thought the Vodafone witness was wonderful, very consistent. So I called him an impressive and truthful witness. And the upshot of that was that it cost him a lot of money, and obviously cost him his reputation as well, which is why he now pads around on the pit lane. Okay, so beware oral agreements, certainly for $150 million in the back of your car. Okay, so I want to introduce you to another concept very quickly called the doctrine of privity of contract. Now, because contracts are about setting up a series of obligations, it's important that they're set up between the people who are parties to that contract. Sounds blindingly obvious. That means that you cannot transfer the liabilities or the benefits to somebody else. And similarly, if you had tried to pass it on to somebody else and they failed in the performance, you're still liable. Because the privity of contract says to us, only a party can sue on a contract that's that's part of that contract. I can't think of a sort of simple way of explaining it, but we'll look at an example in a moment. That obviously, for me, creates lots of problems in the construction project environment because effectively we are in a sort of multi-party environment. We have multiple stakeholders. We have lots of people involved in contracts. We establish contractual relationships, subcontractual relationships, cross relationships with all sorts of people. It's a common endeavour amongst our stakeholders. And in a very sort of simple example, you could see that here we have a number of parties or stakeholders in a construction contract. The headline contract, sorry, difficult to show that, is the one between the contractor and the employer. The employer has a contract with the architect to provide services, separate one with the QS, separate one with the engineers. In this case, the architect is employing a landscape architect and an acoustic consultant, and the contractor has a number of subcontractors. Privity of contract tells us that if, for example, the contractor fails to pay his subcontractor, the subcontractor cannot then go and sue the employer for payment. There is no contractual relationship with them. Privity of contract says that can't be done. Similarly, if the landscape architect fails to perform, the architect cannot bypass his or her responsibilities and say to the employer, it wasn't my responsibility. The employer will say, our relationship is that relationship. There is no relationship here. Okay? So there are disadvantages to that, but you can also see there are clear advantages as well. We could also say that if the architect failed to perform in some way that affects the contractor or his subcontractors, the contractor can't sue the architect. They have to go to the employer, and then the employer would go to the architect. So it's a sort of rather difficult chain. But you can see already that that has advantages to that, but there are also problems associated with that. Especially when sometimes the chain might be broken. Say the contractor goes bust. How does the subcontractor get payment? Well, actually, the employer has no contractual duty to pay the subcontractor. Very quick overview. We'll revisit this in the contract lectures. Okay. There is one exception to that, and it's called the law of agency. Now, if you remember earlier on, I said right at the beginning of the professional bit, I said we spend our lives acting as client agents. We spend a long time doing our client's bidding. And that's true. So when we make a town planning application, the box at the top says agent. It doesn't say architect. Something that often offends people, but that's the case. Because we are literally making this application on behalf of our client. This is when literally you're standing in their shoes, you're doing what they've asked you to do. So an example in a more contractual environment is that in a JCT contract, the contract administrator and the architect is acting as the client's agent. So it can be seen as a sort of exception to the privity of contracts. If I go back to this diagram, can't remember whether I... No. Okay. We know that in a conventional JCT contract, the architect does have a role in the contractual relationships, in managing this relationship. But he or she does it as an exception to this principle of privity of contract. And because it's an exception, the duties of the agency duties, the things you can and cannot do on behalf of the employer, are have to be very highly regulated. Regulation is probably the wrong word. Have to be very clearly defined. Where would they be defined? Well, actually, they're defined in the contract between the contractor and the employer. Not in this contract, but in this one. And if the architect does something outside the agency functions stated in the contract, then he or she has no power to do that. Similarly, if they don't do what they're meant to do, they're liable for that inaction or incorrect action in the same way that the employer might be. So the quite onerous duties come from our position as agents in contract administration. Now, we're not going to talk about that today, but we'll touch on this. We'll come back to it. But you can see from what I'm saying that when it comes to this thorny subject of contract administration that we were talking about earlier, that you need to be very clear about what your functions are or are not. So it's quite specialized. Okay, so moving on. Well, I'm probably going to answer these questions. I've probably answered it already, but you're stepping into the client's shoes, as I've said. That's the way I would like to think about it. You're doing things they could do. They could issue instructions. They could visit the site. They could inspect the work. But they don't. They give those powers to you. And in giving those powers to you, by the way, they withdraw the powers from themselves. They can't do any of these things. They can't go and give direct instructions. Actually, they can't even go and visit the site unless the contractor allows them to by agreement, and normally they would do. They can't issue variations because they've given you those powers. You can't both have it. So I said because it's an exception, your power, your authority originates in the contract. So what are the dangers? Well, did you have the power to act in the first place, and have you exceeded your authority, or have you actually failed to do something that you were meant to do? Okay. So we'll gloss on. Okay, so we have a contract, whoopee. Okay, we have an agreement. And then we have to think of what was accepted. I must speed up, actually, so I'll whiz through the rest of it. It is getting a little bit easier, so don't worry too much. And the question is, well, if we've got this agreement, and our English legal system is obsessed by when the agreement was formed and what it was, then we need to be very clear about that. What was accepted, and we find that out in what are called the contract terms. So we have two sets of terms, though. We have what are called express terms and implied terms. And express terms, the definition is that these are terms that the parties created themselves. They could be oral or written, but in construction contracts they're written. And note just here, so not all the things that were said before the contract was formed might end up as terms. So I'm thinking of all that sort of messy world where we're negotiating contracts, where we might be looking at subcontractor agreements, things that might have been agreed, if they're not in that final agreement, aren't part of the agreement. Implied terms are those that aren't written down, but might be implied into the contract. That's rather odd, because I said at the starting point, one of the starting points about this is that we are trying to create certainty. The idea that something is implied, to me, creates uncertainty. Anyway, we'll find a way around that in a moment. Okay, implied terms could be by custom, dangerous, so implied by the courts to reflect something that was assumed to take place. So, and that tends to be industry specific. But more commonly, they are what's called implied by statute. So this is where one of the few rare cases where statute steps in. So we've got the Supply of Goods and Services Act says the supplier will carry out the services with reasonable care and skill. No blinding insight there, because if you look at our contracts, the way they're written, believe it or not, they tend to say this explicitly anyway. They'll say something similar. We don't always say necessarily, especially in our agreements, that we're going to carry out the services within a reasonable time, but that's implied by statute. And then obviously you'd expect to pay a reasonable amount. And I've said note about codes and standards, so our codes also inform what we mean by reasonable, what we mean by performance. So there's another layer of control here. Now, so what I'm just going to give you an indication then is, when we look at a contract, you'll see that we can now sort of begin to apply these principles. And I'm not sure I've covered them in these slides. I thought I had, but before I just move on, and I probably will have covered it, but I'll say it here. I talked about express terms before the implied terms. Express terms being the terms we create ourselves. So an SBC 16 contract contains a series of express terms, 126 pages of it. But also you need to think of the other documentation that sits below the contract. The drawings, the specifications, the schedules. Those are all express terms. But these other ones are implied by statute. Another one is, we talked about adjudication as being an unusual case where Parliament stepped in on dispute resolution in construction contracts. It is an implied term, even if it isn't in the contract. You can't say, I've excluded adjudication because we haven't included in the contract. It is an implied term. Even if it's not there, statute tells us that it's there, but we just didn't have to refer to it. In the same way that you've actually agreeing to carry out services with reasonable care and skill. Okay. Right. So I'm just going to give you a few examples here of how this might apply. So we talked a lot about agreements, and here's an example with minor works. Well, first of all, we start with the headline agreement. This agreement is made by, And there'll be a set of basic facts, the works, the documents, so in a sense, all of these things for express terms. What are then called articles, which set out the contractor's obligations. We said this is about the law of obligations. Who the contract administrator is, stroke architect, because this is a defined agency role, we need to know the name. And then what are called the contract particulars, the start and completion dates. And below that sits, so that's the agreement basically, and then below that sits a series of conditions, again the express terms. I'm not going to read through all of these. But you can see that if you had a letter of intent, for example, it may just say, and I've written them, I'm writing to confirm that it is our client's intention to enter into a JCT SBC 16 contract with you in the sum of so-and-so for the works at such and such with a start and completion date of such and such. I might then say, the terms and conditions of the SBC 16 contract apply, but that doesn't help very much because these conditions are a menu. There are lots of things that you strike out. They're not fixed. You can make choices throughout these 126 pages. So it begs the question as to what is the contract, and of course the devil is always in the detail. And when you get an argument, there's going to be a disagreement about what the details said. And the courts will look at the paper trail. They won't fill the gaps for you. They don't go and say, oh, I know you meant this and you meant that, but the decision is this. They don't do that. It's binary. They will say, you're right or you're right. They don't do anything else. And they make that decision on the basis of the evidence on the paper trail. Okay? So similarly, if we went to SBC 16, we'll see the same sort of thing. I'm not going to go through this in any detail, but also something about settlement of disputes occurs in both of those contracts. We've touched on adjudication, so we know about that. If we look at our architect's appointment, guess what? It's a similar sort of thing. We have a scope of services. We talk about payment. There might be technical aspects that really don't apply to other types of contract. A net contribution clause, I'm not going to talk about what that means, but Indu may very well talk about that tomorrow. There'll be issues around copyright. Who owns the products that you produce? And here, actually, we have another unusual situation where there are laws around copyright, which says, actually, you own the copyright. That's what the law says, unless you give it away. So default position is you own it. You might give a license, you might give it away in some way, or you might sell it. You could deal with dispute resolution. We have to deal with how a client makes complaints and termination limitation period. So again, I've brought this back now to something I talked about earlier. So one way of, say, looking at a letter contract is, we're not using a standard form. How do we know our letter meets all our requirements? Well, you could go to ARB standard 4.8 and it will tell you the 8 things that need to go into a letter contract that will satisfy the codes of conduct. So you can see that's a danger zone. If you didn't know that, then you might think you're quite a reasonable letter contract you've written, but if it hasn't met those requirements, then actually you've fallen below the standard that would be expected of a professional architect. Whether the ARB took any action will depend on how far you fell, and also if that failure was central to a failure in performance of the contract that you thought you'd agreed. Anyway, so they do take a reasonable view. All right, so we just, I've referred here to the contract documents. And essentially, the agreement says this is what the contract is, but we can also see we've got all these other documents that are referred to in the contract that are also, in a sense, express terms. So there's a huge level of complexity in construction contracts. And that might also include subcontractor packages. So we've got the terms, we've made an agreement, we now get to the contract itself and performance. Now, the performance is obviously determined by the contract terms, hence the obsession within English law of trying to find out what that is. Because if we don't know what the second column is, we can't really make any decisions around what's in the third. So that's at the heart of all those disputes about those letters of intent I've just referred to earlier. And guess what? The performance is determined by a number of things within the contract. So it might be around cost. What was the agreed cost? But guess what? In SBC or general JCT contracts, that's subject to variation. It might be around time for completion. That also is subject to variation. The requirements that are set out in the documentation, but there could be alternatives, there could be variations there. And then payment terms. All of those are aspects of contract performance. Okay, so in a nutshell. In our professional services agreements, what we're saying is that we are trying to meet a fundamental standard of performance. So there we are, there's an obligation to exercise reasonable skill and care and diligence. The diligence is the time bit, to do it within a reasonable time. We haven't specifically said anything about it, but there's the implied term from the Supply and Goods and Services Act. And then, in order to then the question is, because what we're talking about is a service, the question then comes up is, what should that level be? Remember I mentioned earlier this morning, you're not experts. If you said you were, then obviously there would be an expectation the type of service you delivered was of a different nature, which is why you must never say that you're an expert unless, of course, you are. But here we're saying, in our contract terms, in accordance with the normal standards of the architect's profession, and that would, of course, beg the question is, what do we mean by that? And that's obviously quite a contentious question. There's very little case law on this, but I haven't got time to talk about the rather bizarre facts around Bolham and Frian hospitals. But the question was, a patient sued this hospital because they felt that the level of care they received fell below the level that you would normally expect. Rather curiously, actually, if anybody knows Frian Barnet in North London, it was a mental hospital. He'd actually had electroconvulsive therapy and they hadn't strapped him down properly, so he fell off and broke his leg or something. But anyway, something rather weird. So he sued them and he said, you didn't follow normal practice, which then raised the question of what was normal practice. It may sound terribly obvious now when we talk about it in the cold light of day, but the question was, well, was it of a very highly skilled psychiatrist? What sort of doctor might it have been? And the conclusion was, unless they said it was for a particular type of expert, it would be what another person in similar circumstances, another professional, would have done. And in this particular case, I can't remember what the decision was, but the point it proved, the legal principle was that the level of professional service you can deliver is measured against what would be the normal expectation of another architect in a similar circumstance doing similar work. So although it's a rather bizarre case, it's one of the few precedents that they could rely on that sort of answered that question. Okay? Failure in performance, well, that's called a breach of contract, and the remedy is, as I think I mentioned earlier, the point is that it's to take you to the point at which you would have been if you had performed the duties within the contract. If you'd done everything you said you were going to do within the time, that would have been fine, but you haven't, so how do we estimate the cost? And essentially that's what the courts are doing. They will agree, the courts or any neutral forum, adjudication, negotiation, mediation. The objective is to try and agree the level of compensation, the gap between what whoever did, and what you agreed to do. There are cases when actually the contract has changed so much that you couldn't really, it didn't make sense to say, I know we agreed to do this, but actually by the time we've got to this point, it's changed so much that we can't identify what that gap is. And it does happen. So you might get a case where initially a contractor started off building, I don't know, a single-story dwelling, and that as the contract was changed at various times and it ended up as a sort of 12-story apartment block. That sounds a bizarre example, but the point being the contract had changed so much that there wasn't this original reference point. And this is a rather nice case where the law steps in and says, well, no matter, we will just pay you what we think is due. So forget about the principles of contract law because they're not going to help us here. We've got to find another solution. So let's look at what payment should be. So could be that you terminate the contract. So that might be the decision. It could be that the courts decide that you carry out the work. It's extremely unlikely. Courts don't like to impose what they call specific performance. You must complete the work you said you were going to do. The reason for that is if you don't do it, then they have to go back to court again, and they've got to try and resolve that. So really all the courts are doing is setting up a system of compensation. And then lastly, and we don't need to worry about it this particularly, you might end up having to issue an injunction to stop something happening. So you don't need to worry too much about that. Okay, so finally, ending the contract. Well, we can do it, as we say, by performance. We could do it by terminating the contract. So you'll find if you look at your JCT contracts and your own professional services agreements, there'll be a clause around determination. How do we finish this thing if we can't complete it? And it might be that you do that just by agreement. You might just say, do you know what, it's never going to happen. Let's end this agreement. Or as I mentioned with the sort of Mozambique flooding, it could be around frustration. We just cannot, the contract is literally frustrated. We cannot perform it because something else has happened. Sometimes it's things like civil war, circumstances have changed beyond our control. So you can see the legal system is trying to take account of every sort of eventuality. Other issues? Well, we talked a little bit about the issue I said about, does your, if you complete the contract and you have performed the duties within that, are you liable for anything that might occur in the future? And the law says, yes, we are liable for actions that we've taken, things that we've done. And then the next question is, well, fine, but how long for? And that was a question that wasn't really very clearly defined. In fact, it was a case with Arabs with a design failure that was identified a very long time after the completion of the work. And the question was, what's the reasonable length of time? The contract didn't help. It didn't say anything. There wasn't any particular precedent that would help. But there was felt to be an almost infinite liability. And that, obviously, if that was the case, everybody would stop doing anything. This was a case where Parliament stepped in and said, in order to resolve this, we'll create a limitation period. And we'll stick our finger in the air and look at current practice and say, if you've signed a contract, then it's 6 years. If you've executed a deed, it's 12. And we need a long stop of 15 years. So, if you've signed it, if it's executed as a deed, and the problem is identified in the 11th month of the 11th year, then we're going to allow you 3 years to make that claim. And that is how we might relate to sort of what are called latent and patent defects. Issues, well, reasonable skill and care. We commit to design with reasonable skill and care. It's the wording in the Supply of Goods and Services Act. We do not agree that a building will be built so as to be fit for its purpose. The contractor agrees to that. In your international work, I mentioned that we have this limitation period, which is a statutory limitation period. You'll find there are other regimes have different limitation periods and also different ideas of liability. So if you do any work in the UAE, it doesn't really matter whether you are the designer or the contractor. If you've had any hand in contract administration as architect, you can't in making a claim, or somebody can make a claim, you can't distinguish between something that was designed with skill and care or something that was built so that it was fit for purpose. Their law just says it doesn't really matter. If you've had any involvement in the contract process, you, the architect, are liable for the lot, which is a huge responsibility, because you're not only now liable for your fees, but you're now liable for building failures as well, which might not be anything to do with design. It could be a construction failure. They also have a different liability period. They have what's called decennial liability, which is more common in European states. So 10 years of liability. They don't distinguish between whether something is a contract or a deed. I'm only throwing that in because just to explain that if you are working on international contracts, a little knowledge is a dangerous thing. I'm exhibiting a little knowledge, I should say. I don't know a lot in depth. We then get into areas where we might get round privilege of contract by agreeing what are called collateral warranties. Indy may talk about those tomorrow morning, perhaps. And things that occur in design and build contracts, which we'll talk about in one of the other sessions, and similarly in dispute resolution. So I'll just finish with dispute resolution, because I said I would. On UK construction acts, we have a right to adjudication. Even if it's not in a contract, you can go to adjudication. Otherwise, you would look to the contract for other methods of resolving disputes. Very few cases go to court, but when Eddie went to court, it cost him $5 million. Okay, thank you, everybody. Sorry, I've overrun again, but we'll see you, 4 o'clock, is it? Okay, thank you.